You smell that? That might be the beginning of the end to kill an ATF rule because that's the smell of victory. And it smells like federal because that's where we're at in today's case. We're talking about Vanderstok v. Garland. We're talking about the frame receiver rule, which tangentially is, of course, related to ghost guns. What happened? Why are we here? And what happens next is what we're going to be covering today. My name's Tom Grieve, former state criminal prosecutor, criminal defense attorney. Enough about me. If you're curious, read my bio in the description box below. What we're going to be covering here today is an emerging federal court decision that just came out that vacated the ATF rule concerning frame receivers. Where is this thing going next? Well, I can answer that one quickly. It will invariably wind up going to the relatively pro-gun. When I say relatively pro-gun, I do mean it's actually probably our most pro-gun circuit court. Remember, we have the federal district courts. These are the trial level courts when we're talking about federal courts, basically, the federal court system. And then above that sits the federal circuit courts. So since this case came out of the Northern District Court of Texas, the next step for that will be the Fifth Circuit Court of Appeals based out of Louisiana. And then the next step above that will be going to the U.S. Supreme Court should and when it get there. All right. So what are we talking about? Well, we're talking about, of course, what is a firearm? When are parts? When are gun kits? When do we get to a gun being a gun? And the ATF recently really tried to move the line on that. And the court basically said no. Why? Well, let's explain a little bit of the history here. So what we're talking about, of course, comes out of the 1968 Gun Control Act, which basically that was one of the cornerstone laws that are out there. Of course, we had the National Firearms Act before that. And there were other gun laws too, but the 1968 Gun Control Act was really the act that really kind of set the framework, kind of developed the FFL system, and really kind of sunk the federal clause, the federal teeth into the Second Amendment in a lot of different ways. So that act defined firearms four different ways. We have any weapon, including a starter gun, which will or is designed to or may readily be converted to expel a projectile by the action of an explosive. So does it shoot something by action of an explosive? Number two, the frame or receiver of any such weapon. So if you don't know what the frame or receiver is, think of it like the Mr. Potato Head hull. That's the thing that we kind of connect things into, like the barrel, like trigger parts, the sear. It's the thing that without nothing else will kind of connect or work. Now, obviously, you need all parts of a firearm for it to work. Otherwise, why do we have it on there, right? So at the end of the day, think of it like the Mr. Potato Head hull. It's tends to be the thing that everything kind of clicks into, if you will. Imperfect definition, but a good conceptualization if you don't know what it is. And then number three, any firearm muffler or firearm silencer. So that's NFA, subject for another day, as well as any destructive device. Now, notably, the Act, of course, also does not regulate any kind of antique firearms. Again, subject for another video. Well, flash forward about a decade. That's when the ATF arrived on the scene. Now, remember that Congress cannot pass laws that govern every last little application of what they're talking about. In other words, they'll say, look, if you do this, then X. But the question is, what's the definition of this? What's the definition of do? When are you crossing the line? And where does the line expand to in every single little case? That's why there's 400 and some odd federal agencies and sub-agencies, which some people call the fourth estate. I call that as well, because it's kind of the fourth wing of government. These agencies, for better or worse, it's their role to basically kind of step outside the box and to define within the parameters of the statute. They cannot exceed or expand the law, but they are to define and figure out, okay, when are you coloring within the lines? When are you not coloring within the lines? However, if they decide to themselves try to push the line beyond where the statute is drawn, where the lines are drawn by Congress, that's where you get Vanderstok v. Garland. That's where you get this case. Because in essence, the judge in the Northern District Court of Texas basically said, look, you are exceeding the statutory authority of what you can do here. Remember, the ATF cannot pass law. They can interpret law. They can apply the law. Now, of course, they get checked by the judiciary and ultimately should push come to shove as well as by Congress and so forth if they decide to intervene, launch investigations and all that other kind of stuff. But they are to decide is this particular snowflake, does this fit the definition of snowflake, or at some point does snowflake become ice or something like that? So I don't know if you follow me on that analogy or not, but that's kind of the gist to it. So under the ATF's new frame receiver rule, which was promulgated in 2022, this was basically the first big update in decades where they've really decided to touch what is a frame or receiver. Because keep in mind, a frame or receiver is a gun. It may not look like a gun, but it is a legal firearm under federal law and therefore can be regulated as such. So this is an extremely important question. And under the new rule, basically what they did is they split apart the words frame and receiver, and they said that one of them applies to handguns, the other one of them applies to long arms. So we're thinking rifles, we're thinking shotguns, things like that when they're not in some sort of pistol configuration or anything like that. And it can be applied to when these devices are, of course, disassembled, non-functional, and all that kind of stuff. Okay. So what we're talking about here specifically now is the ATF basically saying, look, if the line was here by our definition, by the ATF's definition, we're now expanding it, because keep in mind, the ATF has said, look, if you are building a receiver, if you're building a frame, by the point that it reaches 80% of completion or more, we're now going to regulate it as a firearm. So, of course, there's been a cottage industry that has cropped up where they manufacture things to less than 80%. Then they'll sell jigs and molds and all that other kind of stuff. So if you're a hobbyist and enthusiast, whatever your case may be, you can then complete the assembly. So you take the device from 79% or less beyond the 80% threshold. Now it's regulated as a firearm. Well, a lot of politicians have gotten it in their mind that this is an awful thing. Subject for another video. Let me know in the comment section below if you want me to follow some of the statistics about that, because I do have statistics about so-called ghost guns and all that other kind of stuff as it relates to crime and on a state-by-state basis. So let me know in the comment section below if you want to see me explore that as a topic of another video. But the ATF basically said, look, yeah, we're no longer looking at it that way. If we're going to determine whether or not a device can be readily converted into a firearm, there's basically 8 full criteria we're going to be looking at. The time it takes to do so, how easy or difficult it might be, the level of expertise that's involved that you need, the level of equipment. Is this something that's really kind of cheap, or is it going to be something that requires a lot of expensive gear to do? The parts availability in order to do all this, in order to complete the build, including the jigs and molds, the expense of doing all this, the scope of the project, and then, of course, the feasibility of, okay, is this something that somebody can feasibly do at home, or does this require expensive lathes and all that other kind of stuff? So the ATF basically tried to move the line. And by the way, they also said that the final rule also extends the definition of firearm to include weapons parts kits. There was a Supreme Court decision about 20 years ago, a little over 20 years ago, called basically the Thompson contender case is what it is. We've covered that in other videos as well, but the gist to it is it goes into the whole notion of constructive intent, constructive possession of when do parts kits become guns. I'll link that maybe in the comment field below so that if you guys want to explore that more, you can. It's a really fascinating case, and it is still the binding law when it comes to when do kits become guns. Of course, the ATF decided to kind of play their own rules, and the Northern District Court of Texas said no. Basically, in a nutshell, the Northern District Court of Texas found that you guys are exceeding your statutory authority. You're trying to move the line beyond where it is. So if the line goes from here to there, the Northern District Court of Texas said that you're trying to push it way off to the other side. Can't do that. Vacated the final rule. Now, this only likely applies in the Northern District Court of Texas. It will invariably be appealed by the ATF, by Merrick Garland, by the Justice Department to the Fifth Circuit. So expect to see it taken up there sometime in the weeks and months to follow. But look, it's obviously a fantastic start. I'm not in any way, shape, or form trying to play this down. And of course, as all of you probably know, ATF rulemaking, kind of a big hot button issue recently. So any court decisions going towards the whole notion of what are the limits of ATF's power to define the scope of the Second Amendment, to define the scope of statutory limitations as set by Congress, all of this is going to be incredibly, incredibly, incredibly important. We also, of course, want to acknowledge the fact that the FPC, Firearms Policy Coalition, an immensely important pro-Second Amendment group, has led the charge in this case. Be sure to check them out. Consider becoming a member if you've not already done so. I have to give them that plug. And guys, if you stuck around this far, congratulations. We're going to get to the quote of the day. Waste no more time arguing what a good man should be. Be one. That's by Roman Emperor Marcus Aurelius. So we thank you for sticking around this long. I'll, of course, keep following this case. And as always, I will see you in the next one. Thanks and take care.